Hello students, welcome to the business law session for the B.B.A 5th semester. In our previous class, we had discussed about the breach of contract. What you mean by the term breach? So, breach is the violation or breaking of the terms and conditions of the contract by one party. And the party who breaks it is called as a defaulter, and the other party is called as the aggrieved party. So breach may be of two types. It is anticipatory breach or the actual breach. So these are all the aspects which we have discussed. Now, when the breach takes place, when one party has violated, has broken the terms and conditions of the contract, the other party is put into the loss. He sustains the loss. So now, what is the remedy for that person? So now we are going to study the remedies for the breach of contract. So where there is the violation of the terms and conditions of the contract by one party, the other party gets the right to claim the remedies. So first there must be here the breach. Breach has to take place, then the other party here gets the right to here claim the remedies against the defaulter. So what type of remedies are available for the aggrieved party? What remedies he has got? So totally there are 5 remedies: rescission, damages, specific performance, quantum merit, injunction. Specific performance, quantum merit, injunction. Totally 5 types of remedies are available for the aggrieved party. So this is the question you can get in your examination for 10 marks, as I already have told you. What is breach and state the remedies for the breach. So first you have to give the definition of the breach or the meaning of the breach. Then speak on these, mainly the remedies. So here the examples are most important for us. Here through the examples only we will try to understand it. So the first type of the remedy available is rescission of the contract. The other party. So here the breach has taken place. One party is at the default. The other party, the aggrieved party. So what he decides? He decides mainly to rescind the contract, to cancel the contract. So he does not want to go to the court of law and put himself in those mainly the legal binding here, mainly obligations. So he wants to rescind the contract. So that is one type of remedy. So he can rescind the contract. So the aggrieved party has got the right to rescind the contract or cancel the contract, to put an end to the contract. That is called as rescission. Or the next one is here the aggrieved party can claim the damages. Damages is mainly here the relief for the loss he has sustained, compensation for the loss he has sustained. So that is the damages. So this is the most common type of remedy which is claimed in the breach of the contract. The most common type is the here damages. So damages is considered to be the most common type of the remedy which the aggrieved party claims from the defaulter. So what type of damages are there? Ordinary damages, remote damages, or here nominal damages and vindictive damages. 4 types of damages have been given there. So ordinary damage. What is the ordinary damage? So always I told you, you will be understanding this here through the examples. So ordinary damage is to what extent the loss has been caused here to the aggrieved party, to that extent the damage is to be claimed. So that is called as ordinary or general damages. Whatever loss he has sustained, to that extent he claims the damages from the defaulter. Now for example, A has promised to sell here 1 ton of cotton to B here for 1000 rupees. 1 ton of cotton here for 1000 rupees. A has agreed to sell it and he has promised to sell it, but he fails to supply here this cotton. He is unable to supply that, mainly the cotton. So B has to purchase that cotton from C for 1200 rupees per ton. 1200 rupees per ton. So now what is the actual damage caused here to, mainly here B? What is the actual loss he has caused? He has sustained the loss of 200 rupees. Otherwise he had to pay 1000 rupees to A. What is the actual loss he has caused? Is 200 rupees. So that is here, just I gave you the example. What is the actual damage that has been caused here because of the breach? Here that damage claimed is called as ordinary or general damage. Only to that extent it is claimed. So it is called as ordinary damage or the here general damages. This is the first type of damage. Remote damage, or it is also called as special damages. Special damages. So special damages are those which are very remote. So they are not immediately here coming to here the force of the performance here in the execution of the contract. They are called as remote damages or special damages. In case if there are any such here, mainly the claim of the special damages, it should be very made clear at the beginning itself. At the beginning itself, it should be made very clear. For example, A has agreed to supply 1000 here, mainly here cotton, here 1 ton cotton for 1000 rupees, and B has here mainly agreed and he is ready to pay 1000 rupees, but he puts a condition: you have to supply it on so and so date. The date is given because he says that I am sending this particularly to C and I am selling that to here 1200 rupees per ton. So this is made very clear by B to A. B to A, he has made it very clear there. And now here the thing is that here the special damage is made clear to A here. So it is at 1200, he will be selling that. Now A commits the breach, he doesn't supply it. Here B purchases it from T for 1200 rupees. For 1200 rupees, he purchases that, mainly the hair cotton. He has purchased it to 1200 and he has supplied it to C at the cost of 1200. Now suppose think, if he had taken it for 1000 rupees and given it, he would have got 200 rupees here benefit. He would have got 200 rupees benefit here per ton because 1200. Now he has purchased from D for 1200 and he has sold it to here C here for 1200. Now what is the actual loss he has sustained? So he has given 1200, 200 more here to him and he has also lost his, mainly the commission there. So he was able to get 200 rupees, but now he has put that in here, mainly for giving it to D. For 1200 he has purchased that 1 ton of cotton, 200 rupees extra he has given. And if he had taken it from B and sold it to C, he would have got the profit of 200. Now if he gives it only for 1200, he cannot get that profit. He cannot get that profit of 200. That 200 is mainly the special damage. It is a special damage which is made here the clear at the time of the contract is made. So special damages, if there are any such terms and conditions of special damages, it should be made known at the time of making the contract. So both the parties must be aware of the special damages. So that is remote or special damages. Nominal damages is in the here default has taken place, breach has taken place, but aggrieved party has not sustained any loss, but he brings a case against the defaulter for damages. So in this circumstances, as there is no loss caused to the aggrieved party because of the breach. But still, to teach him a lesson, he has filed a case there. So in these circumstances, the court awards him nominal damages. Whatever the court feels it is fit, it awards it. So you cannot measure the damages there. You cannot measure that damages there because no loss has been caused there. No loss has been caused there. Hence, it is at the discretion of the court to award the nominal damages. It is just nominal damages. Vindictive damages are in the form of punishment. Vindictive damages are in the form of punishment, or they are also called as exemplary damages. Exemplary damages or vindictive damages. Usually this is given very rare. So what is the purpose of awarding the damage? Is putting the aggrieved party here mainly in the same status as he was there if the contract would have taken place. So he has sustained the loss. To make up that loss, this damage is given. But here it will be in the form of punishment. Here it will be in the form of a punishment. So that is here usually given very rare. Exemplary damages. Now for example, in the contract of marriage, if the breach takes place, in this case, because of that, here mainly the honor and the thing could not be measured here, whatever loss is sustained in the contract of marriage, or where we come across here in the case where a banker refuses to honor a check in spite of sufficient funds in the account. The check gets bounced and that is a loss of that goodwill of the person to whom that check is given. So suppose A has given a check to B and B has gone to withdraw it, the banker refuses. The banker refuses to give the money. In this case, the check is said to have bounced. B comes back to A and says it. So it is a goodwill has been lost. Usually in the contract, in the business, that goodwill is most important. So in the contract of marriage or in such a here where the banker has refused to honor a check in spite of sufficient funds, here in that case, here the aggrieved party here can go for vindictive damages. The court will award vindictive damages, but it is very rarely. Usually the ordinary damages are very popularly claimed there. This is here the 4 types of damages we have. And usually remember, the damages will be only in the form of money, nothing else. It is in the monetary form. Damages will be always in the monetary form, in the form of the money. The money that is in circulation. That is, we are to call it as legal tender. So this is here the damages we have got. Then the other 3 just you have to remember. Specific performance, where monetary compensation is not possible, the aggrieved party can go for specific performance. Where it is not possible to compensate in the form of money, here specific performance is awarded. So usually, for example, here A agrees mainly to sell his old car to B for whatever price it goes. So B agrees to purchase it because he has got a lot of sentiments to car, because once it was owned by his grandfather. So he has a lot of sentiments towards it. But later A decides not to sell it. B says that he is ready to give more money, but A refuses to sell. So in this case there is a breach. B can go for the remedy of specific performance because his sentiments cannot be measured here in the form of money. So specific performance will be awarded in this case. So that should be here the mainly there should be no possibility of here compensating in the form of money. Monetary compensation is not possible. Then in that case the court will award the specific performance. Specific performance is nothing but whatever terms and conditions are there in the contract, the court will direct the defaulter to perform his obligation. That is what we call it as specific performance. This is one. Quantum merit can be claimed. Quantum merit is for whatever work you have done, you can claim the money or the damages. The quantum merit. So you can claim for your remuneration commission for the work what you have done. For example, A is a publisher and he has made a contract with B, who is given the responsibility to write every week one story for his magazine, Age magazine. So the contract is for 6 months, it is there, and after 3 months, so every week he is sending the story, and it has been agreed here to pay the price on the completion on whatever amount is there on the completion of 6 months. So he goes on writing. Here after 3 months the magazine is stopped. The publication of the magazine is stopped. So later here B, he is not required to send those, mainly the remaining part. Now what is about the, here he has sent the stories and which have been published for the 3 months. So for that case he can go for the quantum merit. For whatever work he has done, he can claim the remuneration. So for 3 months, whatever was agreed, here keeping that as a base, you can decide what will be the amount for 3 months, and that much has to be given by the publisher. So such quantum merit is whatever work you do, here for that you are entitled to get the remedy or the remuneration. That is called as quantum merit. This is one type of the remedy. And the last one is injunction. Injunction is an order from the court directing a person not to do it. He is not required to do it. Now for example, here between two houses, there is an open space. Here A and B are living here together, and there is an open space. B makes an encroachment in the open space, but actually that open space is a passage. He makes an encroachment. So A, here mainly his passage is obstructed there. So he asks the court for the direction to stop B from encroaching that passage. So B issues the injunction, order of the court it is, not to do so. So that is called as an injunction. So injunction is the direction from the court here for not doing it. So these are the remedies which can be claimed for the breach of the contract. So first there must be breach, and after the breach takes place, the aggrieved party here can claim the damages against the defaulter there. So in the conclusion you can mention that these are the remedies available for the aggrieved party. The most common type of remedy is the claim for the damages. So this is how you should conclude your answer there. These are mainly here the damages here that can be claimed, like ordinary, remote, nominal and vindictive we have studied, and the other here remedies that are there. So in the conclusion you have to make this. So this here mainly comes to an end of the module 2. We have completed the module 2. This is the last topic of the module 2, and from next class we are going with the module 3, which is about the specific contracts, where we are going to study 5 specific contracts: contract of indemnity, guarantee, bailment, pledge, agency. Once we complete this here, then remaining is sale of goods act and the other 3 small acts. So module 4 and 5 there. Module 3 we are going to commence in the next class. So we will conclude here the module 2. Thank you.